Good morning. I'm Merrick Masters, and welcome to United Auto Workers Organizing Watch. Today is Independence Day, July 4th, 2024. So happy 4th of July, Independence Day. We're here today to talk a little bit about the UAW's defeated effort to organize the workers at Mercedes in Vance, Alabama. The UAW lost the vote, which took place in May of this year and was announced by the National Labor Relations Board on May 17, 2024. It lost the vote by 2,642 against the unionization of the plant to 2,045 for. This is the first formal attempt via a certification election that the UAW has had on record at the Mercedes plant in Vance. It comes on the heels of a major victory that the UAW had at its Chattanooga plant with Volkswagen. The union loss at Mercedes, as reported in the press by NPR, comes as a relief to Alabama's political leadership. The governor of that state, Kay Ivey, was reported to have said, "The workers have spoken clearly. Alabama is not Michigan, and we are not the sweet home to the UAW." United Auto Workers President Fain issued a statement, which was posted on the union's website after the announcement of the defeat, in which he said that Mercedes engaged in egregious illegal behavior. The federal government of the United States, as well as the German government, are currently investigating, Fain goes on to say, Mercedes for the intimidation and harassment they inflicted on their own workers. We intend to follow that process through. And indeed, the United Auto Workers has exercised its legal right to file objections to the election that took place. Specifically, it has filed an objection asking for a rerun of the Mercedes election. The National Labor Relations Board will have to make an investigation to determine whether or not the charges of unfair labor practices leveled against Mercedes have merit. The UAW said over 2,000 Mercedes workers voted yes to win their union after unprecedented illegal anti-union campaign waged against them by their employer. What that tells us, their statement went on to say, is that in a fair fight where Mercedes is held accountable to following the law, workers will win their union. Now, this is a charge and an assertion made. There is no evidence available at this point in time to establish the record of such. That will have to be determined through the investigatory procedures of the National Labor Relations Board. The United Auto Workers leading up to the decision and afterwards has filed several unfair labor practice charges against Mercedes, and you can look at these charges. The information from the National Labor Relations Board website is reported here, and you can click on the case number and look at the charges available at this time. This will only have the charges that have been made, not any accompanying evidence until that is accumulated by the regional directors and other entities within the National Labor Relations Board, which will conduct an appropriate investigation. Again, I emphasize these are just charges at this point in time. No definitive conclusions have been reached by the NLRB or the courts, which do have the right to hear decisions of the NLRB on the merits of the cases brought. In the course of organizing campaigns, you really have a ground war between the company and the union to a certain extent, particularly when they're in opposition to each other and the company has decided not to remain neutral, which is its right, but to make its case against why the workers should have a union. They will employ consultants, management consultants, to come in and help them advocate their position. There is nothing in and of itself illegal about this, and I make no claims whatsoever about the proprieties or improprieties of the consultants that were hired by Mercedes. But they have to file so-called LM2 reports or LM20 reports, and this is from the website that the UAW has about their reports that they file, including LM10, LM20, LM21 reports. This is from the LM20 reports from the Employer Labor Solutions Company that was filed on May 29th. It gives you an idea of what it has to report to the government, the Department of Labor, about its activities to help companies in organizing campaigns. Tells you a little bit about the purpose, which was to persuade employees to exercise or not exercise their rights, as to the manner of exercising the right to organize and bargain collectively, and a little bit about the nature of the contract that they have with the employer, whether it's verbal or written. You have another report from another company hired, a labor relations specialist company, the same form that was filed, and information about the purpose that the company was hired for and also the nature of the contract. Again, you have JBL and Associates, May 30th, 2024, filed a report with the Department of Labor, again, on the purpose of the activity and the nature of the contract. Similarly, with respect to labor relations specialists, another contract, I presume, that was reported on June 27, 2024, that tells you a little bit about the nature of that contract and the purpose for which it was made. Again, these are all in and of themselves legitimate activities that companies undertake to make their position known to the employees. But these firms come in and they help employees articulate a case, and companies that often have deep pockets will spend a considerable amount of money to influence, through the activities and advice of these specialists, the interests of workers and their efforts on whether or not to support a union. This is a matter of considerable concern, and the National Labor Relations Board will take the weight of the evidence about the employer's practices in conjunction with a variety of activities undertaken in nominal opposition to the union to determine whether they violated the National Labor Relations Act, particularly the provisions that stipulate it's an unfair labor practice to interfere with employees' right to organize. Again, you can have decisions made by the NLRB which are appealable to the courts, so it may take a long time for these decisions to work themselves through to final conclusion. I hope you'll stay tuned to more information about this. In a subsequent episode of this, I'm going to address the issue of the extent to which the federal courts, as a result of recent Supreme Court decisions, might take a look at the National Labor Relations Board from the perspective of determining whether or not it may have exceeded its authority as an agency. There have been cases brought against the National Labor Relations Board by companies that allege that the structure of the board is unconstitutional, and a recent decision by the United States Supreme Court has said that agencies need to be circumspect in their interpretation of the rules and regulations and follow the strictures of Congress more so than they may have been in the past, and this could have implications for the National Labor Relations Board interpretation of the law as it is applied to union activities on the organizing front. Stay tuned. This tells you a little bit about myself. I hope you'll subscribe to my YouTube channel and click like. Thank you for watching. Have a good day.